owned. But if you heard testimony that was given from the U.S. Attorney in Arizona, Paul Charlton, in 2007, that he disagreed and approved of those tactics and declined the request to prosecute the cases of wide receiver, would you dispute that at all?
I'm not aware of Mr. Meehan's Mr. Charlton's testimony.
It's his testimony that he declined to prosecute those cases. And just so you know, the other facts I've been able to glean is that the Kevin Carvel, who's a DOJ criminal division gang unit supervisor, in September 2009 called it a semi-dormant investigation, gun trafficking investigation by ATF. And in 2012, Jason Weinstein called it a case from years earlier, which in my mind suggests that it was not something which was current.
The wide receiver was dormant and then was brought back to life.
Well, I want to know why. That's a pretty good question, because do you know who's Laura Gwynn?
I'm not sure. I don't know.
Well, let me tell you who Laura Gwynn is again, going back. Apparently, Laura Gwynn was an attorney from Maine Justice who was sent by Lonnie Brewer to prosecute gun cases. And around 2009, September 2009, she was sent to Arizona to prosecute gun cases. In her email, September 2nd, 2009, she sends an email to Jim Trusty in the United States Department of Justice in Washington. It says, "It's my understanding a lot of those guns walked." So we had an attorney from your department sent to Washington who sends a communication back to mid-level or senior-level people in the criminal department saying, "It's my understanding, I'm on the scene, guns walked." Sure. And I want to know why, when a former U.S. attorney, based on those opinions, declines to prosecute cases because he does not like the procedures of ATF, and an attorney who goes and identifies gun walking, why would a subsequent administration send down attorneys and resurrect these cases for prosecution?
Well, I mean, we want to try to hold accountable the people who were responsible for crimes that were committed. And I would guess that people took into account the techniques that were used in making the determination as to which cases would, in fact, be prosecuted.
Well, I sure do think that that's correct. And who do you think the people are that sit there and take into account the techniques that were used? Those people in ATF that are looking for the determinations from the department about what tactics are appropriate. And what signal does that send when the previous U.S. attorney declines and says those aren't appropriate tactics, but the new one comes down and says, no, we believe that we're going to prosecute these cases in which those tactics were used. But this was simultaneous as well, I know, to an effort in 2009 when Lonnie Brewer actually went down and discussed the idea of traveling to Arizona to meet and plan ways to coordinate gun trafficking. So I just wanted to know why that determination was made. But let me just switch to one other thing, because again, it comes back to the idea of who knew what and when. It was Fast and Furious an OCDETF case.
Yes, I think received an OCDETF designation.
And you know, I'm holding in my hand the U.S. Attorney amount, and we've all lived with this, and I know you know
you have, certainly.
We've spent our time. I look, and it says, well, I'm talking about the places, authority of the United States Attorney, and what needs to be approved by the Department of Justice. Approval is required for organized crime strike force cases, of which Fast and Furious. Every significant action in the investigation and prosecution, from case initiation, court-authorized electronic surveillance, witness immunities, witness protection, and other important events must be approved in advance by the Organized Crime and Racketeering Section, which is in Washington, D.C., the last I looked, correct?
That's correct.
Okay, so we have the department in Washington who's actually making determinations about the sufficiency of the new investigations that are taking place, the OCDETF investigations that are taking place, correct, which became Fast and Furious.
Well, I'm not sure exactly. It's one of the things we have to try to, again, figure out. Who exactly?
Well, Mr. Holder, I'm figuring it out. I'm watching the documents. No, I'm giving you that route.
Well, there's clearly, I understand the regulation that you've read. Now, the question is who actually made the necessary approvals, who was involved, why did they do something that might have been contrary, as you say, I don't know, to what the previous U.S. attorney did. These are the kinds of things that I think we're going to find out from the Inspector General. I have not done a top-to-bottom review yet. I've not been allowed to do that. I can't do that.
One of the things we know is there's approvals as well for wiretaps. And in the conclusion of approval for a wiretap, we know that we have to put together a document which is an affidavit from law enforcement, an affidavit in which to be approved that has to suggest that all other law enforcement options with respect to investigative techniques have been exhausted and are not. So I don't have access. I would ask, but I suspect you're not going to let former federal prosecutor and myself, Mr. Gowdy, have access to the 7 separate affidavits that were included as part of the wiretap authorizations that were approved by your department. Would we be allowed to have access to them?
And, you know, I'm not sure what the history is in that regard.
They're sealed. I know they're sealed.
They're sealed. And I don't know whether or not, as part of our interaction with Congress historically, the department has sought unsealing orders in that regard. I just don't know.
I would like to know what was in those wiretap affidavits with respect to which we know there needs to be the articulation of the investigative steps that were taken.
Yeah.
And if
I'm sorry, go ahead.
Well, I'd like to know if we would have the ability to be able to review those. And even in some contexts in which we could negotiate, the only thing we want to see is the extent to which there may be references to tactics that were used by ATF with respect to gun walking.
Well, as you and Mr. Gowdy will know maybe better than anybody else on the committee, these kinds of applications don't always go into all of the techniques that are used in a particular investigation.
But I don't know that, and I'd like to know that.
Well, no, I'm just saying that generally. And so that there is the possibility that the review of the material submitted by the field in Washington would not contain something that would say guns were allowed to walk, or however it might be.
But there's also the possibility that it would. And what I want to know, because I do know that your authorities would have from OEO, and it would actually go up higher to Mr. Weinstein, if I'm correct, who would have to review that affidavit. And so it would be for a pretty serious high-level guy in the criminal division that would have in his hands that affidavit if he so chose to read it.
Yeah, a Deputy Assistant Attorney General has to ultimately approve the wiretap before it goes, wiretap application before it goes before a court. And we have tried to put in place some new measures with regard to OEO and how these things are handled. But I will, you know, I will look and see what we have done historically with regard to these wiretap applications and see how we'll proceed, given the request that you have made.
Thank you. My time is
up. I thank the gentleman. We now